pronounce that name, did I? No, but now you're okay. Okay. All right, as you all know, because you heard me talk at the beginning, Judge Kelly is actually here, but not here. She's participating remotely and she's paying attention to everything you'll say. So we are ready when you are.
Good morning. May it please the court, my name is Jill Warren. I represent Stuart Medeiros. I would like to reserve 5 minutes for a
Thank you. So let me just ask you a question about the time. Time is of the essence.
Yes,
Was this transaction, was time of the essence, and was that mentioned or featured anywhere?
not in the MSA and not in the final judgment that adopted the MSA. Those words do not occur.
Okay. So if time is not of the essence, we are not precise on our deadlines. And the law is real clear about that. Would you agree?
Well, first, I'm not sure I would agree that time wasn't of the essence. And
But it didn't say it anywhere in any of the agreements.
correct.
Okay. So it didn't say it, in other words, if it didn't say it in the agreements and the parties didn't agree that time was of the essence.
They didn't, but there's a case that says they don't necessarily have to include the language. If there's a contract provision for the payment of the sum, and then if that isn't done.
Was there any harm shown by the alleged delay of several days?
I don't believe that.
How was your client prejudiced?
How is my client prejudiced? Well, the initial agreement indicated that the forbearance was to end on September 1st.
Well, those dates were extended in quite a large part of the things your client did. So let's focus on what transpired in November.
Okay. So I anticipated that. So there's a deadline for the refinance to occur. That refinance is specifically defined in the MSA, which is adopted by the final judgment, to say that, you know, the refinance is not, it's something more than just paper. It is to remove my client, Mr. Medeiros' name, from the mortgage obligation. Initially, the parties are in front of the trial court on, well, initially back before the deadline occurred, Mrs. Medeiros filed a motion that said something along the lines of, I would like you to pay 50% of the improvements on the house, that I'm going to refinance it because I got, you know, some kind of, I had someone come in and say what's wrong.
Right, but that's not material to what you're arguing.
I disagree just a bit, in the sense that it kind of shows where we started, for the same reason that I disagree, with appellee's counsel on, you know, why some of the court's former motions were included in this brief. But I would say that to show that this is where it starts. It starts with the assertion of something that's a bit nonsensical. You know, it makes sense when you say you're going to sell a home and we're both going to be responsible for fixing up the home. And then when we sell the home,
So you want to use this to show that it is that Mrs. Medeiros didn't do all the things she should have done when she should have done it, when she's trying to capitalize on something in the agreement. But ultimately, this isn't about the dispute concerning whether she paid for snow improvements that an appraisal or an inspector identified. This is about whether having a loan closing disclosure that says it was issued on November 16th and the closing date was November 17th and the closing date was November 26th, that the trial court found the closing, she did what she was required to do, and why that's wrong. That's what we're here about today, right? The closing date was November 17th, so she closed on the date that the court had imposed.
well, the closing date on the documents was November 17th, 2021.
Right.
I think that where this kind of starts is that there's a final judgment, there's an MSA. The parties file motions before the deadline, there's an overheard, there's no order. After the deadline passes, so the deadline is September 29th, 2021. On September 28th, 2021, sometime after regular close of business, and by that I mean after 5 p.m. his local time, my client sends an email to Mrs. Medeiros and he says, hey, you haven't properly complied with the MSA because my name is still on the mortgage. She in turn then says, well, I think the response goes something along the lines of, I couldn't comply because you refused to return some paperwork for 2 days. They end up before the trial
Well, he
court.
didn't sign the paperwork that the bank required. He didn't want to deliver the quick claim deed. And so the trial court made findings on this. Do you dispute those findings?
I don't dispute the findings, but I think there's a timeline that's important to consider. So first, he refuses to sign the paperwork as it's written. I believe it's important to note that the trial court did say in their order, or in his order, that the failure to not like the paperwork or not sign it as it was drafted by a large company was in fact reasonable. They didn't find any
It
wrongdoing on
was
his
the
part.
trial court found, and let's just say what we have on the record. He delayed on the paperwork the lender required. He delayed on getting his name off of the insurance policy, because by then he'd already decided she hadn't applied. And then there was, and I don't remember exactly where it is, but the issue of the quitclaim deed was also floating around back there. And so your client, we're now in the middle of October, and you want to talk about what some dispute over an inspector, but ultimately the trial court found, and the loan document confirms that it's in evidence, that the closing date was November 17th.
The closing date on the document was November 17th. The closing date
And
did not.
the document, the settlement agreement, doesn't require a specific closing date. What it says is wife shall refinance to remove the husband's name. And then the series of orders, the November 26th order, it was November 17th, not for time to November 20th, to October 26th. She had until November 9th to secure the line of refinance. And then she had until November, well, he reiterates this on the November 9th. And if she doesn't close by November 19th, she's in hot water. That's what the second order says.
Absolutely, and
And then the third order says she did do that.
the third order says that she closes, and I think that's why it's important to
And
consider.
then the loan disbursement, the closing documents say that it closed on that day. And we got some expert coming in to talk about what is or isn't a closing. That as best I could understand his testimony, nobody knows what a closing is, and it's whenever you want it to be, depending on which factors you want to apply. Maybe it's a rescission issue, maybe it's something else, but fundamentally, without time of the essence, she closes, and it takes a few more days to get the thing dispersed because these are, and documents are going around the planet. But what's the harm? What's the harm? Your client bargained in the marital settlement agreement for these proceeds, for a percentage of these proceeds. There doesn't seem to be a dispute about those having been delivered within whatever X days of the closing and the receipt of all the signed documents. And no lender would disperse those without the signed documents, but the loan's already closed because they're sitting in escrow. What's the harm? Your client got that's the deal that he made.
It is the deal that he made, and the deal that he made was specifically that the closing has more to do, if you read what they agreed to, with the payoff of the Wells Fargo. So the Wells Fargo mortgage is going to be paid off
Well, that happened.
at closing.
Right.
But the parties specifically say in the MSA that she has to remove his name from the mortgage, and I think that the
Well,
evidence
she
is
can't remove
clear.
this thing from the mortgage. What she can do is get Wells Fargo paid off, which she needs a quitclaim deed for the lender to have before they're gonna let him off the hook. That's real property 101.
Correct, and he was not obligated to deliver the quitclaim deed until paid off at the time of closing. So the execution of the quitclaim deed simultaneously, with the removal of his name
Well,
from
no,
the
that's what
mortgage.
refinance satisfaction or removal. It's not conjunctive, it's disjunctive. He was obligated to deliver the quitclaim deed at any of those three things. So refinance, at the very outside, is November 17th. Where was the quitclaim deed then?
I believe that the quitclaim deed at that point had been delivered and was held, but it was not a wet signature.
So it wasn't really a quitclaim deed. So, okay,
So,
I mean, there's no question that this closing became a moving target. And no doubt your client was frustrated by this moving target. And unfortunately, the record suggests that he participated in the target being moved because he didn't do the things that he was supposed to do. So he contributed to it to a certain extent. Then you have the issue of the date of the closing documents and the Truth in Lending Act requirement of the right of rescission, which sort of delays it also. And I guess that we both have harped on it to the point you're tired of hearing us say it, and I don't blame you. How did he get harmed? And that's the part that I have a hard time with, because if there had been a time of the essence clause, we wouldn't have to look for harm. We would basically say he had to close, but the closing had to occur by a certain date. Because there isn't this time of the essence provision anywhere. It means that we can look to a reasonable time, and then reasonable is determined by directly how is he harmed, how is he prejudiced. And that's why we're struggling with this. And that's why we keep asking the same questions over and over again, because we can't get there from here.
well, I think you have to consider that this is a contract inside of a dissolution of marriage proceeding, meaning these parties are providing all of their personal assets. This isn't a removed situation where you have two companies entering into a contract and where's the harm? So you have my client who has his name attached to a fairly large sum of money
I wouldn't like it either. Don't get me wrong. I get it. I wouldn't like it either.
that they bargained for that to not be the case after a certain point in time, which was September 29th, 2021. He refused to sign it, a piece of paper asked for by the lender. The trial court found that that was reasonable. They also found that he delayed it by 2 days. So they extended that deadline, which was the remedy, which, you know, I don't think anyone's arguing that that was not fair or equitable. So that made the deadline October 30th, 2021. And then, because for whatever reason, the hearing is not held until sometime after that, we then have the point where we've extended the deadline, but the parties aren't in court until October 26, 2021. So the trial court hears the case and says, okay, well, this is the contract. I'm going to extend the deadline because although reasonably you still did this thing and it delayed it, she gets 2 extra days. And where we start to have the problem is that that's when closing becomes a term of art and a moving concept. So then the trial court says, well, you have 14 days not to comply with the MSA or the final judgment that adopts the MSA. The trial court says something different, okay? And that different is, I think, goes to the appellee's argument that you should have appealed that order. That order was a modification of the terms of the MSA, and if you wanted to fix it, you should have appealed it then. Well, hindsight is 2020, and then we did not know that closing was going to be a moving target. When you're in court on the 26th, the order comes down, I think a couple of weeks later, potentially. At that point, closing starts to be closing, and then there's a clear close.
We're here now, and the total timeframe that you're dealing with, you know, in his perfect world, the refinance, because the document doesn't say closing date, the marriage settlement agreement. What it says is refinance, and etc. So in a perfect world for him, this would have happened at the end of September. And instead of being at the end of September, it's the end of November. And part of the reason it's the end of November is that your client held things up. Part of the reason is the vagaries of getting a loan, getting a refinance. We got, what was it, 3 people that had to have signatures involved here. And you're asking a court to supervise it. And for whatever reason, either you're not getting into the court timely, or the court is taking time to issue these orders. But fundamentally, and I know as Chief Judge Morris said, you're tired of hearing this, but we're talking about what amounted to maybe 60 days, of which several days at least were attributable to your client. What is, and there's no time of the essence, what is the harm? I get that your client, I think the trial court made a finding on this, would have preferred to force the sale of the house, and I think that's why we're here. But what, at this point, Mrs. Medeiros has refinanced the house, and your client wants us to do what?
Your Honor,
You want us to force the sale of the house, to send us back to the trial court with instructions to order the sale of the house?
yes.
Wow, okay.
And if I may, there's been a
How
lot of
is
talk
that
about,
fair?
I don't
And
think.
isn't this, there's some equity involved here, so how does that turn out fair?
So I would tend to agree with the trial court that he can't do equity at this point, that we're looking to enforce a contract. And then we have, this is a bargain for contract, and Ms. Maderos or Mrs. Maderos bargained for a contract with a very specific deadline to refinance the home by removing.
What the
my
court said was, it's not your quiet title, it's your to enforce marital settlement agreement. Marital settlement agreement is executed in included equity. And there are equitable considerations here. So tell me, how is it equitable to now, 2.5 years later, force, or 2 years, however long it's been, 2020, we're gonna send this back in home. Judge Berlin to enter an order forcing the sale of the house and sell it at the end of 2023. How does that work equity? Where is equity there? And your client got he got the benefit of this bargain that he originally made. Get me off the mortgage and give me 30% of the equity at that point based on the 475 number. And now what happens? And how is it equitable?
Okay, so I guess the response to that is he didn't get the full benefit of his bargain. He bargained to have his name off the mortgage by September 29th.
Okay, let's say that he gets a month of credit for the delay. So now he's a month behind getting his name off the mortgage. What's the harm that he suffered while his name was on the mortgage for that month? Because I don't see any record evidence of it.
Well, the harm is that his name is still attached to the mortgage.
How is that harm? What evidence of harm is there?
I think the idea is that we need to see something like, because his name was attached to the mortgage, he couldn't capture some business opportunity that he otherwise would have been creditworthy enough to go get a loan for, something like that. You see what I mean?
I would like nothing more than to offer that to
I
you,
know, I'm
because
sure.
I understand that that's not what we're looking at. However, I believe I'm constrained to the record, and there was no testimony taken on that. That's included in the record. There's the motion that was put in before the deadline that indicates, look, the deadline is what it is. We want to meet the deadline. Otherwise, it's going to financially burden my client. It's going to financially burden the lender. And what was meant by that.
Without an act.
And you're at 15
Absolutely.
minutes, so you're into your rebuttal time. It's your time, you can use it any way you want to.
I think I'm going to have a seat and come back and talk about kind of.
Okay, thank you very much. You'll have 5 minutes when you come back.
May it please the court. I'm Brandon Besley from the Florida Appellate Firm, and I represent Joe Medeiros, the appellee. There was no harm. My client was, in part of this agreement, there's a provision in this agreement that my client is responsible to pay the mortgage during this time period, or it's going to be delayed. He could get a forbearance and delay the mortgage payments, but if he didn't, my client was responsible. My client was responsible for taking care of the home and all the costs involved. Now, she did ask at one point for that 50%. That was early on in the case. The reason why is because it's that little provision is a little bit ambiguous on whether it's something that is to occur at the end of the case, or is it occur when she takes over under the agreement. But Your Honors, the interesting thing about this case is we have all of these different orders that have come out of the court, and I think the only order on appeal right now is the last order for amendment. The other orders were not appealed. They were, from my research, they were final orders. There was no further judicial labor to occur. And so all of those things can be pushed aside because they weren't appealed. And this was the last order was the final order that matters in this case. And if we just look at that last order where the court is actually weighing the evidence, there was competent substantial evidence to support the court's ruling. And I don't see how you get past that. And then even if you do, we have the tipsy coachman argument that there was no time of the essence in this case, and we're only talking about a few days. Even under their experts' testimony, it would have been satisfied in a few days. So I don't, unless you have any questions, I think this case is pretty straightforward. No,
Excellent argument.
thank you.
Keep it short. All right, you have 5 minutes.
One of the points that I really wanted to kind of bring home is that, and was in mentioning the very first motions that started to go back and forth before the deadline, September 15th, 2021, with the first deadline being September 29th, 2021. It became very apparent to Mr. Medeiros that, Ms. Medeiros potentially would not be able to meet the deadline. As I indicated, initially, there was a first email on September 28th, 2021, after the close of business. She had not complied with the MSA. He said, hey, give me the name of 3 realtors. The time is of the essence is, where there's this express recitation in the contract, that time is of the essence. We don't have that here. We acknowledge that we don't have that here. But then it's when did he tell her, when was she on notice that time wasn't of the essence and he intended to enforce this contract?
And he couldn't enforce a time of the essence provision if he had negotiated one in the agreement.
I think I read the case law, Your Honor, to say that there's pretty much 4 ways that someone can be, a time can become of the essence. One of them is, of course, the express recitation. The other one is basically telling, one of the other ones is basically telling the court that, they're telling,
So
sorry.
Western civilization will end if this doesn't get done by the
Well,
deadline.
Rose versus, 4th DCA case, pretty much says different. I mean, it says in the absence of an express stipulation, that time is of the essence. Minor delays are not a failure of a condition of discharging the other party's performance. So, I mean, we have some cases that say directly opposite to what you said. So, I mean, it's kind of hard to ignore that. I mean, that case and what it says.
Right, the time becomes of the essence once the party is put on notice. That was done in an email after the deadline had passed. It was done again through the series of motions. I don't know that how a party could disregard, I don't
But
know.
a unilateral email saying time is of the essence to me doesn't make the contract a time of the essence unless the parties agreed to it. So one party's unilateral position, hey, I'm in a big hurry here, without some reason, I'm in a big hurry because something bad's gonna happen to me if I don't get this done by a date certain. It's a different situation. You can't all of a sudden make a unilateral feeling, a part of a contract, and the other side doesn't say, okay, I get it, I agree, or something like that.
I think perhaps the way that I looked at it was that there was a contract, they bargained for a specific deadline date, that deadline came and went, and then he said, hey, I'm going to enforce this contract. So then reasonable compliance after that is, so I would think that notwithstanding a lot of the other facts, let's pretend that they didn't happen and just say she doesn't comply by the deadline. Let's ignore the fact that, he did something to delay it for 2 days. He sends an email after that deadline has passed saying, hey, you haven't met the deadline. I would like to enforce my contractual rights. And she says, wait, well, I'm still within my reasonable time, whatever that is. It's very subjective. It's not well defined. And at that point, she's got to act within a reasonable period of time to get this done. If she doesn't, then I think he can come in and enforce it. And that's what's happened here. He filed the initial motion on the 15th. He said, hey, she's not going to meet the deadline. She was on notice. He was going to really push the deadline. Appleby acknowledges it in his brief.
Well, then he opened his own can of worms because she said, well, wait, I didn't sign the form, got the insurance policy. I don't know when the the claim came along, but
He did, and she got a couple more days for that, but they weren't into court. So then I believe that the trial court said, okay, well, I gave you 2 days for what he did, which pushed it to October 1st. And then, they didn't get into court until sometime after that. So then the trial court said, well, you didn't know what I was going to say until, October 26th when I said it. So I'm going to give you 14 days. And that's when the problem with unappealed orders comes in, because that's when the trial court starts, really, instead of saying you have 14 days to comply with the MSA or the final judgment.
Well,
It
actually, what the
changes.
trial court said was you have 14 days to get it, essentially a refinance commitment that has a firm closing date. He didn't say she had to close by then, and aren't those orders subsumed? Let's assume that they were technically appealable. Aren't they subsumed in the final order?
And you've got 5 seconds.
Yes or no?
Okay, thank you both very much. You both did a great job. Your briefs were great and your oral arguments were excellent. Yours for its length and depth, yours for its brevity. Thank you.
Thank
Next case is Theo versus Luke's Landscaping. And once again, for record purposes, Judge Kelly is in fact here, even though you can't see her. She's participating remotely in this case, and she will participate remotely in conferencing this case this afternoon when we're through.